Before you start, tell us how the weather is outside.
It was comfortable when I came in. The weather was comfortable when I came in, and I have no reason to think it has changed in the last. On September the 11th, 1967, we initiated a considerate good faith dialogue with the Atlanta Board of Education and Superintendent J.W. Letson. We pointed out to the school officials and all citizens of Atlanta the double sessions, overcrowded conditions, and general substandard educational experiences provided most of the Atlanta Negro children. We cited the discrimination in employment existing in the school system. Our dialogue, started last month, was presented in a patient manner in spite of the cruel history of harsh and unsympathetic discrimination by school officials against Atlanta Negro children and citizens. Atlanta school officials ignored the 1954 decision and acted only when forced by the courts. Negro parents who are plaintiffs in the Atlanta school suit suffered economic reprisals, were abused and intimidated. Negro citizens had to provide citizen protection for some of the plaintiff families due to terrorist actions against them. When Atlanta was ordered by the court to desegregate, school officials employed a cold and cruel grade a year plan, only admitting Negroes beginning from the 12th grade, the most undesirable point of transfer. Only 9 students were transferred to white schools during that historic fall of 1961, when white high schools had thousands of empty spaces and Negro schools were horribly overcrowded. In fact, exactly 6 years ago, from the date of our meeting with the board on Monday, September the 11th, 1961, Negro parents appeared before the school board for relief of double sessions at Turner High School. Today, 6 years later, Turner High School is still on double sessions. In order to aid the school board in making corrective action and to provide quality and equal educational opportunities for all children, we submitted not all of the requests we deemed needed to correct the intentional and unintentional perpetuation against the Negro community, but only 11 of these requests did we present. The relieving responses of the board have been almost nil and limited to 1, information on the area technical school, but no action to give Negroes significant representation on the faculty. 2, appointing only 1 Negro to a top-ranking staff position. 3, consideration of Negro banking institutions. And 4, arranging a monthly forum for citizens to discuss directly with the school board problems of the schools. On the major issue of double session, the board has elected to end them temporarily by purchasing portable classroom units at a cost of nearly $500,000. But with the historic disregard for basic conditions under which Negro children must attend school and Negro teachers and principals must attempt to administer the educational program. No restrooms and other support facilities are proposed. And in each case, the restroom, eating, and library facilities are now about 1/2 of the needs for overcrowded capacity. Negro parents had decided to tolerate the portables, but assumed the restrooms and other support facilities would be provided. There is no concrete proposal offered to provide a permanent solution to the double sessions and overcrowding at Negro schools next year. Let us just examine the situation as proposed by the school board and Superintendent Letson for next year. The new Simpson Hightower School and quality education for our children by other means. The 3 foremost are as follows. 1, we have requested an urgent conference with Attorney Jack Greenberg, successor to Supreme Court Justice Thurgood Marshall, as NAACP Legal Defense Education Fund Chief and members of his staff. The response was immediate and positive. Mr. Greenberg arrives tonight, and we are scheduled to meet with him and other members of his staff on tonight. Our purpose will be to speed up court action and to expand suit to permanently protect our children from the seeming perpetual educational neglect and also to save all Atlanta taxpayers hundreds of thousands of dollars in taxes. 2, we are shocked and greatly concerned over the position taken by the Atlanta Chamber of Commerce on yesterday in face of clear facts and knowledge of existing double standards of educational opportunity for a segment of the city's population that comprises over 60% of the school's population. And let me just add this. The Chamber of Commerce seems to overlook an important moral point here when it chastises some Negroes for their conduct before the board, saying that the board cannot carry on its activities in disorder, and warning or suggesting to Negroes to be orderly and quiet and peaceful, without at the same time chastising and reprimanding the board for having ignored the basic law of the land enshrined in that 1954 court decision which said you ought to desegregate the schools. If the Chamber of Commerce were not so morally myopic in this situation, it would have said to the board, they have some moral responsibility to obey the law as well as these Negroes who they charge to be disorderly. The Chamber evidently disregarded normal sound business procedures that characterizes our Great Forward Atlanta program and failed to research the crucial problems and failure of the school board at least to permanently solve the most shameful problem of all, double sessions at Negro schools, which give most Negro children only 4.5 hours of schooling and white children 6.5 hours of schooling per day. Oh yes, we think we can get.
How many votes would be involved in that?
How many votes?
How many signatures?
Signatures, approximately
40,000.
Yes, approximately that. With our problems, we think that the present board perhaps is incapable at this time of doing the kind of work that needs to be done to rectify the errors in this town. This particular board, you must remember, initiated the pupil placement plan, and I think it is morally and psychologically tied to it and incapable of moving beyond it. So we need a new board with some new fresh approaches, a new imagination, and a higher and greater vision for the possibility of the city. I think this board is incapable of having that kind of vision.
And I think the board might, though they would never publicly state that they agree with Dr. Williams, might somewhat share his opinion. Dr. Williamson said before us in the chamber meeting on 3 occasions that if there was any question about the confidence that the community had in the board, then there were legal means by which the board could be removed. And of course, we are accepting the legal means, which of course is the recall. We think it is extremely important that this method be understood. We are taking our case to the people because we are basically right and our position is just. And with the recall petitions, we can take our case to the people. We can get 40,000 signatures in this city, and we can, of course, at that time, the clerk will be forced to call an election.
All white people who can do justly, and some love mercy too. And there are some Negroes too. So we're not trying to say that you must have 10 Negroes and 2 whites. We want justice, and if the all-white board give us justice, we'll be mighty happy.